Hi, guys. So, good morning. I'm just getting started for today. Just took a look at the headlines and I saw this article on the Hollywood Reporter. It says here Diddy cell raid angers legal team as prosecutors allege witness tampering and recommend no bail. So I spoke about that in the last video I did about Diddy, and I think I was very clear that he's not getting bail. I don't see how he gets bail after this. If what the prosecutors have alleged is true, then he's not getting bail. Okay, he's not getting bail. Now, I was very angry about the whole thing, but angry at Diddy, not at the prosecutors. I was angry at Diddy because I felt that he had undermined all the work that his legal team has done by engaging in these tactics behind bars, using other inmates' phone codes to and on authorized apps to contact witnesses from behind bars. I mean, clearly he knew that that was inappropriate under the circumstances, right? He didn't get bail because he was accused of tampering with witnesses. He's behind bars and then he's going to use unauthorized codes for other inmates. Now, I don't know how that whole thing works with codes and inmates and things like that, obviously. But apparently, when he uses a code, there's a message that, tells him what is unlawful, what is inappropriate. Like you can't use somebody else's code. And it's not something that he would not have known. It's something that is on a recording every time an inmate uses a code, right? So he knew that what he was doing was unauthorized, right? And yet he's going to sit there and he's going to do this to contact a witness in the case as he tries to get bail. And why does he even need bail? Because he tampered with witnesses. He was accused of tampering with witnesses. I am livid. I'm livid because, I'm not his attorney, but I was trying to look at things from his perspective. I was trying to be a defense lawyer. Imagine this is my client. What would I do? I have to tell you, if this were my client, I would ask to be removed from the case because clearly, I don't have any control over this person, right? And all of my work, and it's very stressful work. Being a lawyer is very, very stressful, right? It keeps you up nights, right? And you're not eating, you're on empty trying to help your clients, and they go and they sabotage the case in this way, and then they blame you when you can't work miracles for them, right? This is what happens. They blame you when you can't work miracles for them. So now what's going to happen is he's not going to get bail, and then he's going to say it's his lawyer's fault, and then he's going to fire them, right? And replace them with new lawyers who can't really do any better for him, because if fundamentally he's unwilling to play by the rules or work along with your lawyers and do what they tell you to do, then, if that's his character, then it's his character. And there's nothing anyone is really going to be able to do for him except keep mortgage. He's just going to have to keep mortgaging his homes, lose all his money. And in the end, he's still going to end up having to spend a significant amount of time in prison because he's not doing himself any favors in the eyes of the judge and jurors, potential jurors who are listening to all of this and, have already made up their mind before the case even starts, right? Now, with that all said, his lawyers have filed an emergency motion to, to speak with the judge about this whole situation. Now, I think the bail hearing is on Friday, Today could be Wednesday, but don't quote me because my own mind is like in 3 million places at once. I don't sometimes know what date it is. I should be tracking the date very carefully these days, but I believe on the 22nd is Friday, and he has this third bail hearing, and today is Wednesday the 19th, and they have asked for an emergency hearing. And whether or not they will get this emergency hearing, I don't know, right? But they're basically saying that, the, what does it say here, on Hollywood Reporter? I think his lawyers are basically saying that it was work product, it's attorney work product, it's privileged information, and that the raid that occurred was a violation of his constitutional rights. I mean, it says here in the Hollywood Reporter, in a court filing to the judge overseeing Combs's bail hearing on Friday, his third since a mid-September arrest and incarceration at the notorious Metropolitan Detention Center in Brooklyn, several prosecuting attorneys with the Southern District of New York tell Judge Aaron Subramanian how Combs has obtained multiple inmates' phone lines in attempts to evade scrutiny, control witnesses, and influence testimony while jailed. Okay, so this is the prosecution side. They also allege that he uses a non-authorized messaging app to communicate with the outside world and coerced his family to create a birthday message intended for the eyes of potential jurors before his sensational trial begins in the spring. Um, so they're saying that, where is it where the, okay, so here it is with the defendant's part, the defendant's, the defense position. The means of obtaining evidence that led to these accusations regarding Combs's alleged jailhouse shenanigans prompted the billionaire mogul's legal team to file a rebuttal court document on Monday calling foul on prosecutors for seizing what they say is attorney-client privileged material from his jail cell at Metro. His handwritten notes about his defense witnesses and thoughts on legal strategies for his looming trial were among what was taken away. This search and seizure are in violation of Mr. Combs's Fourth, Fifth, and Sixth Amendment rights, lead attorney Mark Agnifilo wrote in the court. Moreover, the targeted seizure of a pretrial detainee's work, product, and privileged materials created in preparation for trial is outrageous government conduct amounting to a substantive due process violation. Because the prosecutors are currently in possession of privileged material and are actively using this material to detain the defendant, the defense requests an immediate evidentiary hearing. This is an emergent matter because the government has Mr. Combs's privileged notes to his lawyers concerning defense witnesses and defense strategies. Okay, so what do I think about that? It continues here on Hollywood Reporter. New York attorneys call the action a pre-planned nationwide sweep of BOP facilities. Agnofilo's immediate hearing demand included several questions relating to the jail cell raid, including who authorized the search of Combs's prison cell and decided what to confiscate, as well as who passed the seized items to the U.S. Attorney's Office. Okay, so clearly that raid that we heard about a month ago, that was all, a planned thing to get Combs. I mean, that was a cover. That was a cover. I mean, that was not, and that the timing of that was not accidental, in my opinion. If I'm allowed to have an opinion on these matters, I mean, do excuse me if I don't, right? With that said, what do I think about what his lawyers have said here? I think that his lawyers have done the best they can here to counter this. Whether it's going to be successful or not is a different question, right? But you have to fight back. You're the defense. You're angry. Your client fucked up. Your client fucked up. And, look, I'm not a criminal law expert, but I mean, the Fourth Amendment, the Fifth Amendment, due process, Sixth Amendment, what is the Sixth Amendment? The right to, a speedy trial, the right to confront your accusers and so on, I think is in the Sixth Amendment. Fourth Amendment, searches and seizures. I think unlawful searches and seizures. Listen, just because you are behind bars, especially before you have been adjudicated guilty, doesn't mean you don't have any constitutional rights. That you still have rights. You still have the right to be protected against unlawful searches and seizures. And this raid, was this a constitutional raid? Was this a constitutional raid? A. B, I think that, his lawyer is saying that, look, this man has a right to defend himself, even if he encouraged his family to do this PR stunt. This is his right. This is war. He's in a war for his life. He's in a war for his freedom. He has a constitutional right to defend himself. And if a part of that defense is to have a counter PR strategy against the one that was unleashed when that video of Cassie was leaked to the press to show that he is a monster. He has a monstrous side, okay? The man is a monster. He has a monstrous side. And he's like, what about my other side? I have another side. I have children. I have always treated y'all well. Do a birthday party and show people the kind of father that I've been to you. I can't really say that I can't get on him for that. He has a right to defend himself, you guys. He has a right to defend himself. So as far as notes go, he's sitting there in jail. His life is on the line. He's put his hands he's put his life into the hands of his lawyers. It's true. But he's sitting there behind bars. He's the one in there, right? And if he sat there and he wrote some notes and some charts and some I don't know what else you wrote, some white papers and some this and some that, as far as his legal strategy goes and what he wants to see, and he does a tree and he puts, and he does all of this he's strategizing for his case. He has a right to do that. He does have a right to do that, right? He does not have a right to use other people's phone codes, though, right? And contacting someone from jail who is a witness with someone else's phone code is like, is he smoking something behind bars? Is he drinking something? Is he just crazy? Why would he do that? And what? And say what to these people? Did he not think that it could be monitored? You're in prison. You're not prison, jail. You're in jail. You're incarcerated. Why would you do that? Why would you do that? You bleeping fool, right? You screwed up. You're not getting bail. It's as simple as that, right? You're not getting bail. And it annoys me. It annoys me because you could have gotten bail, because the appellate lawyer on this case is very good. She has a very good reputation. All you had to do was sit tight. I don't have a problem with you writing notes. I agree with your lawyers on the notes, but I don't see how they overcome the phone calls and even the app. I don't know how this works. I don't know, unauthorized apps. I mean, how is it unauthorized? The fact that they say it's unauthorized doesn't mean that it was. Like, what is that? How does this work? I'm sorry, I don't know. I'm completely ignorant of this stuff. But, the phone calls on other people's phones to call witnesses and then paying people. I mean, and you're trying to get out of jail on bail because you obstructed justice is just so completely and monumentally stupid, Puffy. It's just so stupid. It makes me angry because I know your lawyers are really working their asses off on your behalf. Well, anyway, so what do we do here? So what we do is we argue that, we being the defense, the defense. I'm livid, you guys. I'm livid with Puffy. I'm livid. Okay, so we're going to argue that the raid on his jail cell and the seizure of his notes were a blatant violation of his constitutional rights, which undermine the core principles of a fair trial. Okay. Now, we know that the Fourth Amendment protects individuals from unreasonable searches and seizures. And we also know that, just because Puffy is behind bars doesn't mean that he's exempt from his constitutional protection, as I said earlier. Now, by targeting materials that are clearly marked or intended as privilege and that pertain to defense strategies, he has a right to strategize for his own defense, right? These are privileged and they pertain to his defense strategies, his notes, okay? The prosecutors have overstepped their bounds by seizing them and releasing them to the public in this manner and to the courts, right? These handwritten notes in particular, which include his thoughts on legal strategies and potential witnesses, constitute attorney-client privilege material, whether or not the prosecutors were aware or not. Just because he's in prison doesn't mean that he cannot, create or generate attorney-client privilege material. Okay. Now, the deliberate seizure of these notes not only breach the confidentiality essential for an adequate defense, but it also erodes, in my view, the trust and the candor that is necessary between a defendant and his legal team, right? I mean, this man was clearly trying to help out his legal team. He was trying to help out his legal team with his own defense. There is no law against that, right? Now, this government action with regard to the raid and the taking of these personal effects disregards, in my view, the sanctity of work product and poses a severe risk of prejudicing the case against Mr. Combs, also violating his Sixth Amendment right to effective legal counsel, you guys. Okay, what else are we going to say here now? Well, we have the phone. The phone is a big problem, isn't it? So here's what we're going to say, right? For what it's worth. You guys, we're going to say that the use of the phones, his friends, he's got these friends in prison. There are 8 people. Sorry about that. I ran out of space on my phone. But so we're going to say that the use of the phones must be scrutinized within the context of his Fifth Amendment rights against self-incrimination, right? He has a right to not be forced to incriminate himself, right? So while prosecutors suggest that these phone calls were used to obstruct the process and to influence a jury and so on, their handling of this evidence raises serious ethical and constitutional concerns, right? I think that we argue that their handling of the materials violate his constitutional rights. If information derived from these phone calls influenced the decision to conduct the raid or shaped the prosecution's strategy, because the prosecution is strategizing just like the defense is strategizing. The prosecution has a right to strategize just like the defense has a right to strategize, just like Poppy has a right to help with his own defense strategy, right? So they're trying to get a leg up the prosecution by diffusing all this information, using it to authorize a raid to get more, right? And so this is this proper, right? The court has to decide whether the prosecutors acted properly in this situation. If the information that they got from these phone calls influence a decision to conduct a raid or to shape their strategy, this, I think, could amount to an unlawful use of evidence obtained through questionable means. This could amount to an unlawful use of evidence obtained through questionable means. Are you listening, defense team? I'm Johnny Cochran over here, right? You better hire me when I come to New York, you guys, because I'm going to help you win this case. Now, listen, I'm coming to New York soon, okay? Because, it's a long story. So you got to hire me for this, to help you out with this. Now, listen, the government's duty, right, is to ensure a fair trial, you guys. Get this, not to weaponize speculative or inconclusive evidence to justify invasive actions. Again, the government's duty is to ensure a fair trial, not to weaponize speculative or inconclusive evidence to justify invasive action, right? So any use of the phone calls to paint Combs as obstructionist or even coercive without verifying the full context. What was the context, you guys? Context matters in every situation. Context matters. What was the context of these phone calls? This is what is missing from this explosive motion by the prosecutors, right? any use of these phone calls to paint Combs as coercive or obstructionist without verifying the full context compromises the presumption of innocence and potentially distorts these proceedings. Johnny Cochran over here, right? I'm Johnny Cochran over here, right? I have no money, but I am Johnny Cochran over here. Now, together, right? This is the argument, you guys. The unauthorized seizure of privileged notes and the implications drawn from monitored communications by Mr. Combs illustrate an overreach on the part of the prosecutors that threatens the integrity of the judicial process. I hope his lawyers are listening to this, right? I have a feeling one of them does. The court must act decisively to address these constitutional violations to ensure that Combs's fundamental rights remain intact and that his trial proceeds without the shadow of prosecutorial misconduct. See you in the next one. Take care. Bye.